on the question of complainant's impeachment by the Senate. Counsel argued that once presented with the document, the respondent was duty-bound under Article 47 of the Constitution to take a step and investigate whether those documents were authentic. The respondent ought to have written to the Supreme Court to clarify the issues. She submitted further that Regulation 45(3) empowers the respondent to accept documents and seek clarifications. It was counsel's further contention that under Article 249 of the Constitution, the respondent had the duty to ensure that she protected the sovereignty of the people, since that is what elections are about. On the issue of interpretation of Article 75 of the Constitution, counsel submitted that Article 193(3) ought to be read together with Article 182 of the Constitution on eligibility and qualification of a candidate to vie for a gubernatorial seat. Counsel sought to bring to the fore the supervisory jurisdiction of the High Court under Article 165(2) of the Constitution, and argued that if the outcome of impeachment proceedings can be challenged at the High Court, or one can appeal to the High Court all the way to the Supreme Court if convicted, what is different with a governor who has been impeached benefiting from Article 193(3) of the Constitution? He contended that the respondent did not properly apply her mind to these constitutional imperatives, and as such erred in disqualifying the complainant. Counsel argued that Article 75 or any other article of the Constitution cannot be applied in isolation, that they must be applied holistically. Counsel referred to Article 259(1) of the Constitution. He argued that the respondent ought to have done anything possible to ensure that the complainant enjoys his fundamental rights, even if it meant giving him more time. He further argued that the complainant had all the required documents, only that the respondent demanded for more documents which were brought while the complainant was still seated at the respondent's desk. According to counsel, the respondent had 14 days to verify the documents, particularly the existence of the appeal. He further submitted that this committee has a duty to bring home the rights under Article 38 of the Constitution. Mr. Katisia, in his submissions, told the committee that the respondent was not fair in doing her job and that she was applying double standards. He made reference to Article 47(1) of the Constitution and placed emphasis on the word reasonable as used under that article. He also made reference to Article 24 of the Constitution, in which he argued that the respondent is an authority who is required to ensure the constitutional dictates of equality and equity are met. On the issue of double standards, counsel made reference to a Gazette notice dated 18th February 2021, in which the name of Governor Ferdinand Waititu appeared as a gubernatorial candidate in Kiambu County by election, and yet he had been impeached. It was counsel's contention that if Governor Waititu was cleared by Iebc despite his impeachment, why should they treat the complainant differently? Counsel stated that this fact was brought to the attention of the respondent. He pointed out that at the time he was cleared, Ferdinand Waititu had a case before the High Court challenging his impeachment, same way the complainant has an appeal before the Supreme Court challenging his impeachment. Counsel further pointed out that Iebc is a party to the matter before the Supreme Court, and therefore the respondent should have been aware of the appeal. On his part, Dr. Haminwa referred the committee to Articles 259(3), Article 38(3), and Article 159(2), 193(3), and 21(1) of the Constitution. He argued that Article 75(3) of the Constitution is not applicable at all in this matter as a stand-alone provision. Mr. Mukele, counsel for the respondent, began his submissions by clarifying that Governor Ferdinand Waititu has not been cleared for purposes of the general election to be held on 9th August 2022. He argued that the documents presented by the complainant as a basis of alleging bias and discrimination only relate to a by-election in 2021 and not any other election. He explained that the Gazette notice referred to by the complainant's counsel was not a clearance, but an intent to participate in an election. According to counsel, this is procedural, and it is done before candidates are cleared. Counsel pointed out that even the complainant was gazetted as an aspirant ahead of the nomination process. On the issue of Article 38 and the complainant's political rights, counsel submitted that the respondent acted in full appreciation of rights under Article 38 of the Constitution and the laws that govern the conduct of elections. Counsel urged the committee to disregard the submission that the degree issue was brought to the attention of the respondent at 3:30 p.m. and that the respondent allowed the claimant to bring more documents the following day. It was counsel's position that these issues do not appear in the complainant's affidavit and therefore amount to adducing of evidence from the bar. Counsel contended that there was no request by the complainant for extension of time to allow him present his documents later. Counsel summarized the reasons for the respondent's refusal to clear the complainant as failure to present original degree certificate, failure to comply with Article 75 of the Constitution, and failure to present certified copy of degree certificate from the relevant university. According to counsel, the complaint as drawn only challenges the disqualification of the complainant under Article 75 of the Constitution. Counsel also played a video to demonstrate that the Supreme Court's appeal was brought to the attention of the respondent on the 8th June 2022, after the period of clearance had lapsed. He contended that this was an attempt to supply out of time documents that should have been presented on the 7th June 2022. According to regarding the claim made by the complainant that evidence of the existence of Supreme Court appeal was presented to the respondent in form of a letter from the complainant's advocates, counsel for the respondent that the said letter was received at 4:31 p.m. Additionally, counsel argued that the letter referred to by the complainant's counsel only referred to existence of an appeal without any proof. Counsel argued that in addition to the issues concerning Article 75, the disqualification of the complainant was also due to failure to submit documents on time in contravention of the set timelines. Counsel also revisited the first video played by the complainant's counsel and argued that the video does not show any of the documents that the complainant claimed it showed, and therefore the contents are irrelevant. On the issue of interpretation of Article 75 and Article 193(3) of the Constitution, counsel submitted that the issues before the committee are not related to Article 193(3). He referred the committee to Section 22 of the Elections Act and Section 13 of the Leadership and Integrity Act. Counsel maintained that Article 75 and 193(1) cannot be read together with Article 193(2) and 3 because Article 193(1) is a self-executing and self-governing provision. Counsel sought to distinguish between eligibility and qualification as used in Article 75 and disqualification as used under Article 193(2)(g of the Constitution, and submitted that eligibility in its operation is very wide in scope. He urged the committee to look at Article 193 in relation to Articles 10 and 2591(b) of the Constitution. Counsel made reference to Article 181(1) of the Constitution 2010 that spells out the grounds of impeachment. He also made reference to Gazette Notice number 10904, published on 18th December 2020, and argued that some of the grounds listed in the grounds of impeachment of the complainant including crimes under national laws, which according to him do not fall under Article 193(2)(g, but which fall squarely under Article 181 of the Constitution, 2010. Counsel held the position that there cannot be a review or appeal for impeachment under Article 193 of the Constitution. On documentation, counsel referred to paragraph 7 of the respondent's replying affidavit to the effect that certain documents must be presented to the respondent before an aspirant is cleared to contest. He argued that there has to be a demonstration that there is an active appeal, which was not done. The respondent told the committee that she disqualified the complainant on 3 grounds: that he did not present an original degree certificate, a copy of the degree certificate was not certified by the university, and for non-compliance with Article 75 of the Constitution 2010. She explained that the complainant arrived at the registration center at 2:30 p.m. and that after going through the scrutinizing his documents, she disqualified him a few minutes to 4 p.m. He, however, stayed at the registration center after he was disqualified. In conclusion, Council submitted that whereas it is true that indeed the Commission plays a facilitative role in the electoral process, this must be done within the law. In rejoinder, Counsel for the complainant argued that the complainant was disqualified before his documents were received, that the documents were received at 4:42 p.m. It was Counsel's contention that if the complainant had appeared before the respondent on 6 June 2022, he will have had an opportunity to present his papers the following day. He explained that the complainant was before the High Court on 6 June 2022 and that he did not pick the said date of 7th June 2022, that the complainant complied with every requirement but was disqualified on the basis of Article 75. It was Counsel's contention that the findings of breach of Article 75 of the Constitution was made by the Senate, and that this is why it is important to look at Article 193(2)(g with the emphasis on the words, it quotes, has been found, close quote. He also submitted that Article 193(3) is applicable since the issue before the committee is an issue of eligibility. Council maintained that Article 75 of the Constitution cannot be read in isolation. It has to be read together with Article 193 of the Constitution. Council explained that for one to be elected, the person must be eligible and qualified. This takes us to Article 181 as read with Article 193 of the Constitution. In this regard, Council submitted that the respondent cannot expand reasons for disqualification. He urged the committee to be alive to its obligations under Articles 249, 259, 21, and 38 of the Constitution. He explained that the committee has the duty to promote, protect, and advance the provisions of the Constitution. He asked that the committee should give these provisions life, even where there is none. And this is our decision, the committee's decision. Having listened to all the parties and considered the pleading filed in this matter, the committee makes its determination as follows. To consider the question of whether the decision of the respondent in rejecting the complainant's nomination papers was proper, it must be borne in mind that the respondent rejected the complainant's nomination papers on the following grounds. 1. Failure to present an original degree certificate. B. Failure to present a certified copy of degree certificate. And C. Breach of Article 75 of the Constitution of Kenya. The committee appreciates that Section 22(1)(b) of the Elections Act 2012 provides that to be eligible for election, one must have a degree from a recognized university. We understand this to mean the respondent was required to ascertain the educational qualifications of an aspirant in compliance with Section 22 above. In this regard, Regulation 47 of Elections General Regulation 2012 provides that a certified copy of the certificate evidencing educational qualification shall be submitted to the respondent. The certification that was being accepted by Iebc yes, thank you. Let me take that again. The certification that is being accepted by Iebc for 2022 general election is certification by the university issuing the certificate. To the Commission, only the issuing authority can authenticate a document it has issued. And that is the reason why certification by an advocate is not allowed in this election, in the present election cycle. Additionally, it was admitted that the complainant did not present an original degree certificate. The committee notes that the requirement of an original degree was applied to all candidates across the board, whose part of qualification required a degree qualification. The respondent was therefore justified to insist that the complainant presents his original degree certificate before he could be cleared. In the case of Hezekiah Oira versus Patrick Kwako, 2017, the court stated in reference to the requirement of a certified copy of a document as follows. The law provides that public documents should be produced by the makers, in which case the person producing the same should have the copies properly certified and or sealed. This is the law as per Section 80 of the Evidence Act, which provides that, 1, every public officer having the custody of a public document which any person has a right to inspect shall give that person on demand a copy of it on payment of the legal fees therefor, together with a certificate written at the foot of such copy that it is a true copy of such document or part thereof, as the case may be. And such certificate shall be dated and subscribed by such officer with his name and his official title, and shall be sealed whenever such officer is authorized by law to make use of seal, and such copies so certified shall be called certified copies. It may be true that in 2017 the complainant was cleared using copies of his degree certificate certified by his advocate. That does not take away the requirement that for purposes of the 2022 elections, the Commission require the same to be certified by the issuing institution. It is important to note that the requirement that a degree certificate be certified by the issuing institution was a requirement for all candidates, not only the complainant. To this end, we note that nothing has been placed before this Commission to show that other than the complainant, every other aspirant of equal rank was not required to have their degree certificate certified by the issuing university in order to found a claim for discrimination. The committee notes that the complainant has admitted that this certified copy was presented to the respondent after 4 p.m. This is the same position of the respondent who produced a confirmation that she did indeed receive the original certificate and a duly certified copy at 4:42 p.m. Thus, it is clear that these particular documents were late. However, we understand the complainant to be saying that this should not bar his clearance, as he himself was within the registration center before 4 p.m. Counsel for the complainant argued that since
Cross that out. Yeah, 54, 55, 56.
Yeah,
We go straight to 57.
Oh, yes. In DRC complaint number 236 of 202, Anthony Mutembe Julius versus returning officer Iebc South constituency, where the complainant claimed that he arrived at the registration center, but his banker's check, which he didn't have at the time, he presented himself before the respondent was delivered to him while he was still at the registration center, and according to that complainant, it was his banker's check that was late, and not himself, since he was still at the registration center on time. The committee, in dismissing the complainant, observed as follows. The committee finds and holds that the responsibility of obtaining the banker's check as well as the list of supporters was within the purview of the complainant, and his failure to present the said check and list of supporters within the prescribed time was his own. His omission could have been avoided had he prepared adequately for the nomination process. Counsel further argued that if the complainant had presented his documents on 6th June 2022 and there was a problem, he could still have had a chance to bring the documents the following day on 7th June 2022. Granted, if the complainant had appeared before the respondent a day or so before the deadline, he would have had an opportunity to resubmit his documents. To the committee, it is clear that by the time the complainant presented his degree certificate duly certified by the university, he had already been disqualified. Regulation 2 of the Elections General Regulations 2012 defines close of nomination to mean 4 o'clock in the afternoon of the last nomination day for respective elections. The Iebc issued a Gazette Notice number 434 on 20th January 2022, in which the Commission prescribed at paragraph K that the last day for the nomination of county governor election was Tuesday, 7th June 2022 at 4 p.m. In Edward Mukaya Kamala, Independent Electoral and versus Independent Electoral and Boundaries Commission, 2017, where an aspirant filed an appeal against the decision of this committee, the court recognized the centrality of timelines in electoral processes and the fact that a returning officer is justified to decline to clear an aspirant who presents themselves after the expiry of the time specified. The court stated as follows, and we have included the quotation in the judgment, and that can be read. The Supreme Court, in petition number 3, 4, and 5, Raila Odinga and 5 others versus Iebc and 3 others 2013, while addressing itself on the question of adhering to timelines set under the Constitution and the law stated in its ruling delivered on 26 March 2013 on page 7 of 10 thereof as follows. The parties have a duty to ensure they comply with their respective timelines, and the court must adhere to its own. There must be a fair and level playing field so that no party or the court loses the time that she is entitled to, and no extra burden should be imposed on any party or the court as a result of omissions or inadvertences which were foreseeable or could have been avoided. We therefore find that the requirements under Section 22 of Elections Act as read together with Regulation 47 are standards set by the law, and the complainant was to ensure compliance with the same. We do not agree with the submissions by counsel for the complainant that the respondent needed to do follow-up to confirm authenticity of the documents presented to her by the complainant. We adopt our reasoning in DRC complaint number 239 of 2022, Jeremiah Kiwoi versus Graham Samboja and others, on the fact that Iebc does not have investigative powers and only relies on the documents produced before it for consideration in making its decision. To the committee, the respondent cannot be faulted for her decision on the first two grounds. The third ground for disqualification is indicated in Form 17 as breach of Article 75 of the Constitution. During the hearing, counsel for the respondent submitted on this ground that the complainant was impeached by the Senate of the Republic of Kenya as confirmed in Gazette Notice number 10904 of 18th December 2020, which the respondent relied on in disqualifying the complainant. Counsel submitted that in the circumstances, the complainant is disqualified under Article 75 from holding any public office. However, on their part, counsel for the complainant asked the committee to find that since the complainant has an active appeal before the Supreme Court challenging the decision of the Court of Appeal regarding his impeachment, the complainant should benefit from the provisions of Article 193(3) of the Constitution. This committee was invited to give an interpretation of Article 75 and 193 of the Constitution cited above and the interplay between the two provisions. The parties particularly asked the committee to make a finding as to whether or not the complainant can benefit from the provisions of Article 193(3) on the basis of his pending appeal before the Supreme Court. The committee notes that there is a letter from Registrar of the Kenya Supreme Court, the Supreme Court of Kenya, dated 8th June 2022, which has been admitted was served on the respondent on the said 8th June 2022. As we stated in the Samboja case, Supra, that we, under quote, agree that it is part of the Commission's mandate to consider the documents produced before it during nomination and make a decision on the basis of those documents as to the qualification of an aspirant. In the present complaint, it can be seen from the referred letter of 8th June 2022 that indeed there is an appeal. However, there is an appeal, pending at the Supreme Court of Kenya. This letter was not produced before the respondent on 7th June 2022 by 4 p.m. for the same to be considered in the clearance process of the complaint. We disagree with the complainant's submission that once presented with the document, the respondent was duty-bound under Article 47 of the Constitution to take a step and investigate whether those documents were authentic. In the case of Ethics and Anti-Corruption Commission versus Graham Samboja and another, Kenyatta University and another, interested parties, 2021, Petition 389 of 2017, in which the integrity and educational qualification of first respondent governor, Gratton Samboja, was in question, the High Court stated on the question of IEBC to conduct investigations on documents presented to it as follows. The second respondent, IEBC, mandate is specifically enshrined in the Constitution under Article 88 of the Constitution 2010, which includes the conducting or supervising referenda and elections to any elective body or office established by the Constitution or other laws. The Constitution mandate of the IEBC, it appears, does not include authenticating academic certificates. It therefore follows the second respondent, IEBC, lacks power to investigate and or determine the validity or otherwise of the certificates presented by the intending candidates, as long as on the face of it the candidate presents a prima facie valid document. Therefore, we do not find fault in the respondent's decision on 7th June 2022. The consideration by the committee of and or the interaction between Article 75 and 193 of the Constitution 2010 is unnecessary. The court in Samboja Subra went on to state in conclusion that, and I quote, the Commission's mandate does not extend to undertaking inquiries into the validity and legitimacy of academic certificates and credentials supplied to it by various candidates, but merely acts in trust on the face value of the documents, and that the impeachment of integrity of an aspirant must be on account of an order of the court or quasi-judicial body. The committee relies on the above case and finds that the respondent was under no obligation at all to investigate the documents presented before her. The burden of confirming and proving the existence of documents and facts that they needed to rely on for clearance was squarely on the complainant. We have taken note of the fact that the Samboja case above was not decided on merit since the court found itself without jurisdiction. However, we remain convinced that the conclusions made by the court on this issue are at the very least persuasive, if not binding, on this committee. Before we leave the issue of Article 75 of the Constitution, we think it is important to address an issue that came up during the hearing, where the complainant accused the respondent of having treated him unfairly and with bias. To justify his position, counsel for the complainant pointed out to the committee that Governor Ferdinand Waititu was cleared to run for the gubernatorial seat in Kiambu County after his impeachment as the governor of the same county. According to counsel, during that time, Honorable Waititu's case challenging his impeachment was still pending in court. This position was opposed by the respondent's advocate, who stated that the said Ferdinand Waititu was not cleared to run. Rather, the Gazette notice referred to by counsel is not a clearance but an intent to participate in an election. This position was not controverted and we see no reason to go further. Finally, we rely on the word of the High Court in Protas Waswa Wafula versus Independent Electoral and Boundaries Commission. The court stated as follows: any person seeking clearance, either as a party member or as an independent candidate, must satisfy as of necessity all the requisite constitutional and statutory requirements. He must also satisfy the provisions in the applicable regulations. This is because the electoral process is grounded on the Constitution and the law and regulations enacted to give effect to the said process. Such regulations aim at ensuring a smooth and credible process. Non-compliance with any of the requirements leads to disqualification. Accordingly, it is incumbent upon persons seeking nomination to familiarize themselves with all the constitutional and statutory requirements and also the applicable regulations governing the process to avoid inevitable rejection of their nomination papers. The court notes further that I am persuaded that the disqualification was premised on valid grounds, premised on the constitutional and statutory provision, and also the applicable regulations. I reiterate that it is incumbent upon persons seeking nomination to not only comply with the constitutional and statutory requirements, but also to adhere to the set guidelines and regulations, including observing time frames and submitting the prescribed documents completed as required. Guided by the provisions of the law and the authorities cited above, we arrive at the conclusion that the complainant has not given compelling reasons why we should disturb the decision of the respondent declining to clear him, since he fell short of the mandatory requirements as provided for under the law.
Okay. So, in relation to this particular complaint, in the premise, the committee finds and holds as follows: that the complaint lacks merit and is hereby dismissed. The committee upholds the decision of the returning officer, Mombasa County, rejecting the nomination application by the complainant to run for the position of Governor, Mombasa County. There shall be no orders as to costs.
Much obliged, we are grateful for the patience in listening to us. Our baby that fixed mind of our plan and again political persecution, even in the hand of this tribunal, extended from the chairman himself, and he expected more justice in this particular commission. And for that matter, we do request that immediately we be given a copy of the judgment so that we may proceed to the High Court, as you have made for us very salient grounds for appeal.
Okay.
From the decision that you point.
Okay.
It's a pity that this country is actually placed in the hands of a system that is so polluted.
Okay, Mr. Nyamu, we have heard you. We will. There are quite a number of corrections to be made in the judgment.
Your Honor, we need that judgment like in minutes. Because tomorrow we are not taking any chances. Tomorrow we will find ourselves appearing before the High Court another day. We are told that we are late.
Okay.
So this is a matter that actually before the end of it, this judgment leaked long time ago. I saw it at 5 in the morning. That's when I learned that our petition complaint had been dismissed. So basically, let's have it.
Okay. Salome, how soon can we make the corrections? So you want the proceedings? No, just a moment. Dr. Camino, just a moment. How soon can we have the judgment? I'm asking from our secretariat. Okay, Mr. Nyamu, I am told that these corrections could take probably an hour to make. So let's say before the close, is it possible for you to start doing it now so that as we read the next one, we can be able to have a fair draft?
And we also need the
proceedings. Transcription, how long will it take? Like how long? You can see this gentleman really, 2 hours.
We'll wait.
You will wait? Okay. And then Salome, we can be able to certify them, isn't it? So let's say everything should be done by midnight. But in the meantime, you start so that we can read the following judgment as you are doing that. Okay? All right. Yes.
We'll also be able to be praying for the audio to be supplied with the audio so that we can check.
The audio requires is the audio.
We can supply them in a flash.
The audio sometimes they have to do some editing, or what is the process? It is them. We've contacted a professional firm. They know what to put. Can we give them the raw audio? Just a moment. Just a moment. Just a moment. You want raw audio?
Yes.
Okay. Is it possible? Okay. Okay, let's read the following one while the commissioners consider that request.
Your Honor, we urge you to consider it. Very serious.
It is the commissioners to
The rights of the people of Mombasa are on trial.
No, we
The
agree.
Commission wants to elect somebody from Mombasa.
We agree. We agree. We agree. We agree. We said let us be civil. Why don't we listen to the next matter and see if the reactions will still be the same? Yes, let Dr. Camino say something. Yes, Dr. Camino.
Your Honor, may I say with tremendous respect, I'm very much shocked by the outcome. It's not easy to believe that your committee can come after such a decision. May I say with you with tremendous respect, Sonko is not okay. Some of us are here because we are concerned about the posterity of this country, not about Sonko. Sonko, there was a time when there was no Sonko in the city of Kenya. The ruling you have just delivered really is in conflict with the Constitution we have. If you read the Constitution, you will see that it emphasizes that at some stage one should get a feel that this is the law.
Isn't that the reason why the High Court is there, Dr. Camino, so that you can go there and have those things discussed? We believe.
With respect, when we have a lawyer of your standing presiding over this case, we are appalled by your outcome.
Thank you, Dr. Camino. Thank you.
It's not something we expected from you at all.
Thank you, Dr. Camino. Let us call the next matter. As I told you, I play a facilitative role in this committee. The decision is made by commissioners and not by me. Please, let's have the next matter. Let's just continue being civil.
Your Honor, with respect, I was even canvassing to see whether you can make that we made a judge of Court of Appeal.
But now that has changed.
Yeah,
Okay. What if the decision was otherwise, Dr. Camino? Give us the next decision.
May I mention one matter?
No, just let's have the
I
next.
have a matter here, Your Honor, I would like to mention. I want to go to bed now.
Yes.
There is a case of withdrawing. Civil suit number 137 of 2022. 137 of 2022. And my learned friend, Noreen, put something to say.
Which one is that? Do we have it?
137 of 2022.
No, we'll do that after this, Dr. Camino. We have a set. Okay. Okay, Dr. Camino. I'm sorry.
Your Honor, I'm suggesting that instead of reading the one for Wiper, instead of reading it wholly, and we've agreed. Because we know it says that Wiper be given an opportunity to present another candidate. Just give us a judgment. We go and deal with it. We don't waste time.
You see, Dr. Nani Nyamu.
That is what it says.
Thank you for knowing it in advance. Nyamu, these are our proceedings. Please respect our proceedings. Tomorrow is also there. This is our proceeding. We will do it according to what we want. Okay. All right. That. Why don't, if you know it, then why don't you go and prepare the appeal? Then you seem to know the judgment. Proceed and prepare the appeal.
We are trying, as long as the judgment has not been delivered to us, we cannot leave these premises.
Nyamu, you are my friend. I will not engage in a shouting match with you. It is below me to do that, and we will not do that. Tomorrow we will be friends. These are matters that come and go. Please, let us maintain dignity. There's always tomorrow. There's matters beyond Wiper and Sonko. Okay. Dr. Kaminwa, can I hear you?
137. My land and the Iebc friend has got an application to make.
Please proceed quickly.
She will take about 2 minutes.
Please proceed.
The matter was set aside for the but the claimant has withdrawn the matter.
Oh, we actually received a letter from the national government, CDF, saying that she's still an employee. Yeah. So, but where is that letter? Where is this decision?
Your Honor, there is a withdrawal application here. I have seen it has been filed. And
Okay.
you're bound by this order.
No, we are not bound by this order. We have received confirmation that the first respondent is still employed. So we will not withdraw the application.
Have you cross-examined them or in
But
national government already?
we have already received a letter, a formal letter.
Yeah, there is a withdrawal note here.
Okay.
Yeah.
We will give a decision before close of business today. We'll give a decision before close of business today. We'll give a decision before close of business today. Call out the next matter. It is not very long. We will do it as we have already agreed. Okay. Start with the decisions. Okay, as you have requested, let's have the appearances, please. Honorable Manzo.
Appearances are Kevin Kinengo, Katisia, present. Eunice Lumala.
Yes.
Senior Kennedy Wanyanga.
Present.
Ochieng Obinga, advocate. Present. And also advocates for the interested party are Wilfred Nyamu, present. Senior counsel Dr. Hamilwa.
Thank you.
Myself, Daniel Manzo.
Honorable Manzo.
And also Mr. Bichir.
Yes.
Bichir, also. Mr. Terry. Present.
Okay. Who appears for the respondent?
Mr. Chair, Commissioner,
Edwin Mukele.
Together with Mr. Ndaiga for the respondent.
Okay.
Chair, I've also been requested to hold brief for Mr. Kagushia.
Okay, this will be read by. Yes.
Perhaps with regards to the application of the senior, since we are acting for the complainants, I think we are rightly placed to make this application before this committee.
It is the decisions, just starting from the decisions, we will not go read the facts and the submissions by the parties. It's a 2-page. Please, Nyamu. Nyamu,
I'm sorry.
there's life beyond this.
I'm sorry.
There's life beyond this. Okay. It's all right. You may be dissatisfied by me or by us, but let us respect the process. It is only fair.
We only respect our process that is actually.
Yes, the High Court is there. The Court of Appeal is there. Elections are 50 days away. We have had situations where the courts have said ballot papers to stop being printed so that a candidate can be returned. The harm that we make to this process, and the younger council be behind us, when they see we exchange words and we get angry, these things come and go. We had Raila 2013. People were annoyed. We had Raila 2017. We had nullification of the election. Things happen. But there's a tomorrow. There's a tomorrow. As Dr. Kamino rightly said, there's life beyond Sonko. There's life beyond Wiper. There's life beyond everything. Tomorrow another dynamic will come. Okay. Commissioner Masit.
I'll just focus on, on the decision of the committee. It's just 1.5 pages. This committee is conscious of the ramifications of its decision in complaint number 127 of 2022. The disqualification of the first interested party herein, the complainant, is bereft of a potential candidate for the position Governor Mombasa County. Without urging the complainant's case, we are of the considered view that, taking into account the purpose for which political parties exist, and given the demonstrated intention of the complainant in fronting the first interested party as its nominee, the complainant shall be prejudiced if the committee was to stop at the decision in complaint number 127 of 2022. How then should the committee proceed in the circumstances and in the interest of the complainant as a political party and a cock in the democracy of this country? This committee is aware of the decision of the High Court in petition number 359 of 2013, Diana Kathy Kilonzo and another versus Iebc, and 10 others, 2013, in which the High Court upheld a political party's legitimate expectation to field a candidate for an election under the Constitution and our laws. Provided that the political party has not contravened any law. Deciding the said petition, which coincidentally involved the complainant's political party, the court held, and I quote, "The Constitution is about opening space for citizens so that they can liberally express themselves within its confines. This is the promise of the Constitution which underpins the legitimate expectation of the Wiper Party. One of the cornerstones of exercising political rights is the right to elect a candidate of one's choice on the platform of any of the lawful registered parties. This goes hand in hand with the right of citizens to participate in the affairs of a political party and to campaign for a political party or cause. In our view, so long as a political party has not contravened any that Wiper Party may not have been vigilant and diligent when it came to the fielding of Ms. Kilonzo. Nonetheless, we find that the order that addresses itself to the circumstances and requirements of the Constitution and our society is to allow Wiper Party to exercise its right to nominate another candidate herein of any wrongdoing or contravention of any non-law by the complainant, that is in bracket Wiper Party, in the process leading to the registration of the first interested party. Accordingly, the complainant is utterly blameless, and the committee finds and holds that the complainant deserves an opportunity in furtherance of its legitimate expectation, which, by the decision in the Kathy Kilonzo case, Supra, is underpinned in the Constitution. This committee is cognizant of the fact that the complainant herein did not pray for a specific order for replacement of its nominee should the disqualification of the first interested party be upheld by the committee. However, unless the committee be accused of framing and issuing orders in favor of the complainant, we know that the complainant sought, in quotes, any other relief that the Honorable Committee shall deem it fit to grant, in quotes. The committee finds and holds that this is an appropriate prayer for the committee to issue appropriate reliefs in the circumstances of the complaint. Accordingly, the committee orders as follows. One, the orders as follows, and the chair of the committee will read those orders.
So a declaration be and is hereby issued that the complainant, that is the Wiper Party, has a right to nominate a candidate to contest for the position of Governor Mombasa County in the 9th August 2022 general election. Should the complainant deem it fit to nominate an alternative candidate in place of its now disqualified nominee, the first interested party, the said complainant's alternative nominee shall present his or her nomination papers to the County Returning Officer, Mombasa County, not later than 72 hours from the date of this decision for possible clearance and registration as a candidate for the position. For the avoidance of doubt, this decision does not constitute an automatic clearance of the complainant's replacement nominee to contest for the position of Governor Mombasa County. Whether or not the new nominee is eventually registered as a candidate is subject to compliance with all applicable laws and regulations as shall be determined by the County Returning Officer, and each party is to bear its own costs. Yes, Council. Mm-hmm.
And therefore my client will be seeking to be supplied with a copy of that decision.
For purposes of an appeal?
Yes.
Okay.
And proceeding more specifically, Your Honor, I will be saying that we must supply the audio recording.
Okay. So,
In a raw copy so that it's not presented outside.
good. Nobody proposes to edit anything. Sawa. Yes, Mukele?
Yeah, I have heard the sentiments of my colleagues. There was quite a bit of emotion.
It's now gone down.
Hopefully it has gone down. Yeah. But even as we consider this, it is important for the panel to consider the modern style in which it presents its proceedings. You know, requirements as to raw proceedings and other kinds. I don't know about that. The question is, in what way does this panel present its proceeding for the purpose of any other further action? So, Your Honor, the tribunal then should not be bullied and must act with it.
No, we don't intend to be bullied.
Yes.
That does not exist in our vocabulary. This will come and go. Nyam will remain my friend. Miss Lumalas will remain my friend. Honorable Manzo will remain my friend. I've made new friends like Atisia. I've made new friends Michire. Oginga is an old friend. This will come and go. And most importantly, I don't intend to the Court of Appeal. I intend to go elsewhere. And Dr. Kamino will be my referee. Isn't it, Dr. Kamino?
Your Honor, I am finished.